If you ever searched online about setting up a trust, you've probably seen the terms revocable and irrevocable and wondered, which one do I really need? Here's the truth. Choosing the wrong type of trust can completely derail your goals, whether that's protecting your assets, avoiding probate, or keeping control of your finances when you're alive. I'm Guy Martino, an Indiana estate planning and probate attorney. I've helped hundreds of Indiana families design trusts that work. And today, I'll walk you through the difference between a revocable and irrevocable trust so you'll know which is better for you and for your particular situation. Let's start with the foundation. The revocable trust and irrevocable trust are both legal documents that hold and distribute your assets. But the biggest difference comes down to one word, and that word is control. With the revocable trust, you stay in control. You can change it, amend it, or revoke it completely while you're alive. It's flexible, it's easy to manage, and it's perfect for everyday estate planning. With an irrevocable trust, once it's signed and funded, it's locked in. It's irrevocable. You typically can't change or dissolve it without court approval or consent from all beneficiaries. So the trade-off is this. Revocable trust, you're in control, it's convenient, and it's flexible. Irrevocable trust equals protection, but less control. That's the core difference, and it drives every other planning decision. For most Indiana families, a revocable living trust is the foundation of a solid estate plan. Here's why. A revocable trust allows you to avoid probate, maintain control of your assets, and easily update your plan as life changes. Let's say you create a trust today, but 5 years from now you sell your house and you want to add a new beneficiary. With a revocable trust, you can update that easily. No court, no red tape. You're still the trustee while you're alive. You use your own social security number and you can buy or sell or spend your money just like before. The good thing about a trust is it's also private. When you pass away, your successor trustee can handle your affairs without your family having to go through probate court. So for the average person looking to make sure their assets pass smoothly either to their spouse or their kids or to somebody else, a revocable living trust is usually the best starting. Now let's talk about an irrevocable trust. These are powerful planning tools, but they're not for everyone. An irrevocable trust makes sense when your goal is protection, not control. Here are a few common situations where it might be the right fit. Number one, asset protection. If you're concerned about lawsuits or long-term care costs, placing assets in a revocable trust could protect them from future creditors or Medicaid recovery because you no longer legally own the stuff. You no longer legally own the asset. An irrevocable trust can also be used for tax planning. If you have a large estate, typically over the federal estate and tax threshold, an irrevocable trust can help you reduce or eliminate some estate taxes. While most Hoosiers don't face the issue, it's still critical for high net worth families. Irrevocable trusts are also good for special needs training. If somebody needs a special needs trust to hold the assets for a disabled loved one without disqualifying them for any type of governmental benefits. In irrevocable trusts, we also have life insurance trusts, or ILITs. It keeps life insurance proceeds out of your taxable estate and ensures that they can be used according to your plan. Many times people will fund an ILIT in order to pay some of the estate taxes. We also can use irrevocable trusts for Medicaid planning. That's one area that many people go on the internet and look at. So if you or your spouse ever need long-term care, nursing homes can quickly drain your life savings, often more than $8,000 to $10,000 a month. A Medicaid Asset Protection Trust, sometimes called an MAPT, allows you to move certain assets out of your name so they aren't counted when applying for Medicaid benefits. Here's how it works. When you transfer assets into the trust, you no longer legally own them, which means Medicaid can't force you to spend those assets down. But timing is everything. Indiana currently follows a 5-year look-back period. That means Medicaid reviews all your financial transfers for the past 5 years. So if you made a transfer within the 5-year period and you moved your assets into the trust during that window, those transfers can delay your eligibility for Medicaid. That's why we tell clients, if you're really concerned about Medicaid, plan early. The earlier you set up the trust, the stronger your protection. With the right structure, you can still receive income from those assets, live in your home, and maintain control of your lifestyle, all while keeping your nest egg protected for your spouse or your children. An irrevocable Medicaid trust isn't for everyone. But for many Indiana families, it's a difference between losing everything to long-term care costs and preserving a lifetime of savings for their loved ones. The bottom line is this: an irrevocable trust is like putting your assets in a vault. You give up the key to somebody else, but in return, the stuff is in the vault, so they are protected and shielded from outside risks, namely creditors. Now, there's a lot of confusion out there, especially from folks who heard a rumor or saw a YouTube video saying, just get an irrevocable trust. It protects everything. That's not exactly true. If you transfer assets into an irrevocable trust after you've been sued or right before applying for Medicaid, the court can unwind those transfers. In other words, timing really matters. Also, an irrevocable trust can create tax and administrative headaches if it's not structured properly. So before you set one up, make sure you have a clear purpose and professional guidance. I've seen too many people download a generic irrevocable trust online thinking they're protecting assets, only to end up paying more in taxes or losing flexibility they didn't realize that they needed. A good estate plan should protect you. It should not trap you. So which is better, a revocable trust or an irrevocable trust? Well, here's the truth. Neither one is better. It depends upon your goals. If your top priorities are keeping control, avoiding probate, making things easy for your family, then a revocable trust is almost always the right choice. However, if your priorities are asset protection, nursing home costs, managing taxes, providing for a disabled family member, then an irrevocable trust might be the tool that you need. For many of our clients, the best plan actually uses both. We start with a revocable trust for everyday estate planning. Then we can layer an irrevocable trust later for asset protection or for tax reasons. That's how we balance flexibility with security. Trusts are powerful tools, but the right one depends entirely on your situation, your goals, and your stage in life. If you're not sure which type of trust makes sense for you, don't guess, get clarity. At Guy DiMartino Law, we help Indiana families design trusts that will truly protect what matters most to them. Visit GuyDiMartino.com or call our office to schedule a consultation. And if you found this video helpful, hit the like and subscribe and watch our next video, Why Trusts Are Contested and How to Prevent Them. It's the perfect next step to making sure your trust not only works, but stands up if it's tested. I'm Guy DiMartino. Thanks for watching, and I will see you in the next video.